Well, hello, everyone. This is Wilson Cole, president of Adams, Evans, and Ross, backdoor hire and managing partner of ELOC Global. I am joined by my lovely daughter, Samantha, and general counsel. How are you doing, Sam?
I'm doing well. How are you?
Oh, doing fine, doing fine. We're going to kind of go take a little bit of a shift from the collection side. The good news is 84% of the time we're going to be able to get these collected within the collection process without having to sue them. But there are times that suit is the only option, and that is the only way you're going to be able to get it paid. And sometimes it's because the debtor's ignoring you. They're waiting to see if you're going to elevate up. Or there may be a time that they hire an attorney and the attorney says, I don't think it's owed, which keep in mind, 80-something% of the time that we sue, these things wind up getting resolved. So the attorney is wrong, but he lays down the gauntlet. The debtor's attorney says, hey, we're not going to pay. Do what you got to do. There are times that we have clients that say, well, why don't you go? I know the CFO at the company. Here's a cell phone. We have to explain to them that once that debtor's attorney gets involved, we cannot bypass, by law, we can't bypass that attorney. All communication has to go through that attorney. Sam, kind of give us a discussion on how that works and what those repercussions are, that it's not that we're being lazy, it's that we just don't have a choice. We have to go through that attorney, and if that attorney says, hey guys, we're not going to pay it, sue me, then really the only option you have at that point is to sue them. Kind of walk through in a very layman's terms on why that is.
Basically, it comes from, it starts with the criminal and then it's been, accepted and translated fully through the civil, which are these sorts of matters of you have a right to an attorney. They're keeping your interest at bay. And so, or, at the center, and they're the ones representing you. You don't want, as much as you wouldn't want to affect your case by saying something you shouldn't, and when we're handling it, they're not wanting to have their case jeopardized, and that attorney's there to protect everything. And especially an attorney, if I'm handling it and I'm dealing with another attorney, it is absolute the bar will come down and shut you down if you start going around other attorneys. It is the biggest slap in the face. It is one of the biggest sidesteps outside of stealing money you can make as an attorney. You have to, we've even had where attorneys have resigned, where they were no longer representing a debtor, but they were still on file with the courts. So until the courts accepted the attorney's resignation, nothing could happen.
Yeah, kind of freezes even the lawsuits once it gets to that point.
Yes. Yeah. And then also, in this, well, you're just, I get when I'm like, okay, we've gotten the debtor's attorney saying they're not going to pay it. And we'll go back and say this. And it's like, we always talk about if your debtor says they're not going to pay you, you need to shut up and get somebody else involved. Trust our judgment when we think we can go back and say, hey, actually here, and here, look at these documents and get it resolved. We will.
Yes.
If Absolutely. We're looking at it going, ooh, we need to get this into discovery so that we can force them to have to produce documents.
Yep.
Or looking at it going, ooh, they're just not going to back down. Or if we keep talking, it's going to give them time to cover their tracks.
There you go.
Trust us when we say we need to stop talking and just go ahead and file suit.
I agree with you. And keep in mind, if we have to sue somebody, in my opinion, we failed in our initial task, and that's to get it resolved in that collection process. 84% of the time, we're going to get it collected in the collection process. So that's the good news. 1 out of 6, we're not going to get collected, and about half of those we'll recommend for suit. And, attorney, or when we're talking with the clients, they say, well, the rate goes to 35%. That's just, for the most part, it's almost like an 80-20 or a 70-30 split with us and the attorneys, we make way more money when we get it collected in-house. If we say we need to send it out to the attorneys, keep in mind, we're not trying to up your rate. We're actually making considerably less. And over the long haul, because it's a 12-month process, we're actually going to work a lot longer and harder than we do in most collections. But Sam, you touched on a really good point, is when we tell our clients, when you're told you're not going to pay, you need to shut up, because you will say and misstep and do something. The reason that the attorneys don't want us going directly to the debtor is for that same reason. And the only thing, and in some states, it's all states, it's a bigger pain in the butt, but you have different remedies. And with us being a third-party collection agency, with you being our staff attorney, we also could get the client sued if we totally disregarded the rules of engagement. And if they have an attorney that, basically if the attorney says, well, we're not going to pay because of this, this, and this, and if a client gives us new information, they say, well, they say we don't have a signed contract, but I found an old contract from the CFO that signed 2 years ago. That's new information that we can go to the attorney and say, hey guys, I know you said go ahead and sue him, but as we were getting the paperwork together, we found a contract that was signed by your client. Do you guys want to try to resolve it? I don't have an issue going back to the attorney there, but if we have pleaded the case with the debtor's attorney, and then the debtor's attorney says, well, we paid another recruiter, we knew about this guy, we're not going to pay, go ahead and do what you do, and there's nothing new of substance other than the fact that you just want to regurgitate what your argument was, but maybe say it in a different way. Going back to the attorney, he's going to tell you the same thing. And once you sue him, then at that point, it makes everybody more pliable, because it almost reverses. By suing them, you get the client re-engaged. Right now, the debtor's got his attorney engaged. They're not even thinking about you. They're letting their attorney do all the work. When you sue them, it now just became a much larger expense for that client. And a lot of times the clients, even though the attorney says, I think we can win it in court, okay, it's going to cost them 10 grand to fight it, and they may or may not win, and it may only be a $20,000 claim. So the client may say, hey, try to make this go away for $15,000. I don't want to spend attorney's fees and wind up having to pay them. And so by suing them, you at least re-engage the client's input. Sam, any closing arguments on that?
And I think you also come back to, as much as we can get new information, the amount of times I've also run into where debtors and attorneys provide me with something the client didn't provide originally.
Yes.
And that is why I always ask, send over all documentation.
Yes.
No matter how little, or even if you think it's going to hurt it or hurt us, that especially send over so that I can build around that.
Where we can frame it, where we can absolutely 100% frame it, because, we've had clients, say different things, or they say, well, yeah, I knew about that, but I didn't want to share that with you because that wasn't supportive of the case. Well, one thing is, whenever a client, sometimes the client just doesn't understand, so I have to have a discussion. Going forward, we have to have all the information. If we get into a case where that becomes a habit of a client, we won't handle a client's business and have terminated relationships with clients specifically for that reason, because there's trust on both sides. We've got to trust you, you've got to trust us, and we need all of that documentation. And we had when we hear an argument where the debtor's attorney sends in an argument and the client's fallback position, is something weird, like it's, an exaggeration of the truth. Well, let's talk about what the truth is and attack it from there. Because sometimes we may get new information to where we say, hey, you know what? We want to get this collected for you, but if you sue them, you're going to lose because you told them in this email don't worry about paying me, just give me new job orders, and they gave you a new job order that you didn't fill, well, you just walked away from the debt. That goes back to whenever a debtor tells you that they're not going to pay you, you need to stop any communication and get us involved, where we can protect you the same way that debtor's attorney is going to try to protect them. So if you run into a case of where we're recommending suit, understand that's our opinion is the only way that you're going to get it collected. We're not trying to run up the fee from an economic standpoint. We're actually taking a step back, but that may be the only option that you have. Now, you don't have to sue. You can always close, but having us try to bypass an attorney just isn't going to happen, because it exposes you and us to possible repercussions. And there's just rules of engagement that we have to follow. Sam, I appreciate you sharing the reasons why, from a legal aspect, third-party agencies are governed by a very similar path. What keeps, I guess, that industry side of the industry honest isn't the bar, but it's everybody's errors and omissions insurance, because if you're doing stupid stuff, you get sued. Yep. And with that being said, we've done this for 27, 28 years, 80-something% success rate, collected thousands, hundreds of thousands of accounts, and we've never had, we haven't ever been sued for violating, any of these rules. And there's a reason, because we do follow a path that we have to, and it's just good business practices. Sam, any closing statements before we wrap up this Monday meeting?
I think I'm good.
Thank you. Guys, I'll leave you with one thought. If the debtor's attorney tells you that they're not going to pay you, you need to get us involved. Let us go back and argue. 84% of the time, even if the debtor's attorney told you they're not going to pay you, we can get it resolved. But if it runs through, 84% of the time, we're going to get it resolved. 1 out of 6. If we come back and say, hey, you want to sue them, and here's the reason why, ultimately it's your call. But that's our opinion, and that's just a next step in the collection process. So just kind of trust the opinions on that. Thank you, Sam.
Anytime.